There we go. And we are live. It's 2:30 p.m. on Wednesday afternoon. You're watching Innovation Fika with Donny, live from Stockholm, Technique on KTH Innovation. Today in a kind of a different setting, same place, but different setting. Behind me, you can see the preparations for Demo Day tomorrow. Batch 13 of our pre-incubation program has their big Demo Day when they pitch and tell the world what they've been doing the last year. So if you're in the vicinity, tomorrow, Thursday, March 31st, come by Technique One and watch Demo Day. But that's tomorrow. Today is Innovation Fika, 2:30 p.m. every Wednesday. Innovation Fika with me, Donny, and a distinguished guest. If you want to watch this on LinkedIn, YouTube, Twitch, Univid, or Twitter, you can choose your platform. You can follow me on LinkedIn. I post almost daily about innovation, startups, entrepreneurship, and inspiration. And all my content, as you know, is aggregated on Medium for all the written content, and all of these broadcasts are recorded and saved on YouTube. So check that out as well. So enough about that, enough about me. Make sure to get your questions ready, because today, my dear friends, we're going to do a really Ask Me Anything with a distinguished colleague of mine, Thorunn Grenmark. Välkommen in I studion.
Nice to be here.
It's wonderful to have you here. Exactly, into my big office here. Yes, Thorunn, yes. You are a colleague at KTH Innovation. You are also, I've called you Intellectual Property Expert.
It's fantastic.
It's fantastic. I know. So,
Honored.
and we'll be talking a lot about intellectual property today. So everything you ever wanted to know about IP, IPR, patents, trademarks, just get your questions going into the comments, and we can answer them as we go along this half an hour coffee break chat. Let's start with you. And what do you do? What does a person like you actually do?
I meet a lot of students and researchers here at KTH and talk about intangible assets. And intangible assets.
Okay.
That's kind of weird. You have tangible assets.
Yes.
Like a table or a computer.
So we can actually, a thing, right?
A thing.
Yeah.
But usually the intangible assets are more, you can't touch them, but they are there.
Yeah.
And valuable.
Yes.
So, and more valuable probably than your computer.
Probably, yes. And what is a intangible asset?
It could be an idea, it could be a concept, it could be innovation, it could be a trademark, and design of something, a software program.
But this is interesting. Now we're getting into distinctions here. We're diving straight into the deep end here, because we're talking about the assets that are you said it could be idea, concept, or a method or something. But then the patent and the trademark, that's the protection
of the intangible asset.
Exactly. So that's something to, it's two different things. We have the actual asset, which is one thing, and then we have the protection of it, which is another thing.
Yeah, because it kind of package the intangible asset into something like a patent or a trademark or a design and have registration.
Yeah.
Usually.
One thing I hear a lot, I'll just actually I put the questions in the comment there in the feed there. Please ask questions as well. But I often meet people who say they are going to patent things. I need a patent. I have to have a patent. This is, and they come here with an idea and they want to patent the idea. What is your sort of? Let's say what is a patent?
A patent is an exclusive right to use your invention. It must be technical, and it's not. An invention is a technical solution to a problem, and it must be not obvious and not known anywhere in the world. So it must be really, really new. That could be a problem.
Yeah. No, that's the first thing about a patent. To be able to patent something, it has to be new. So nobody has sort of heard about it before.
No, or public or whatever.
Public.
Whatever. And then it must be not obvious. It must be a kind of jump, a technical jump, I should say.
So it has to be like an inventive step. It has to be like a new way of doing something.
Yeah.
Yeah. Okay.
And it must could be repeated all over again. So it's going to be Not, I mean,
It has to be possible.
it has to be. No, it not really has to be, but you can argue for it to be possible.
So then we're talking about an invention.
Yes.
Right. And an invention is usually
It's always technical.
Always technical.
Yes.
Always technical. And it can be, but how about software and hardware?
Software and hardware, yes.
Can you patent software?
Yes, you may patent software, but not just software. Then you have to have an implementation, like in a car or in something else. You can't just patent a software.
You can't. Okay, so I can't patent my code.
No.
But if the code does something,
yes,
then I can.
That's some technical.
Yeah, I can patent that. Okay.
So you can receive a patent for the car or the windshield wiper.
Exactly.
Yeah.
But then it's actually code that does something too, and so that whole thing can be patented. Okay, so then we're getting close to more what a patent is, because people come and they say, "I want to patent that idea," but you can't just sort of patent an idea.
No, you can't patent the idea. You have to have some kind of tangible thing around it. So
yes. So if you have an idea, which is either a mechanical something, a technical something, or it's a combination of hard and software that is not publicly known, it has some kind of inventive step, and it is repeatable,
yes,
then you can actually apply for a patent.
Yes.
And the patent is, it gives, well, it actually is, it's, correct me if I'm wrong here, but it says that nobody else can do what I'm doing in the way I'm doing it in a specific region.
Yes, exactly. So you have the exclusive right to do it.
And that's another thing that I want to stress, because that's another misunderstanding, because just because you have a patent doesn't mean that you make lots of money.
No.
That only means that you have, the rights to it.
Yeah.
So then you have to do something with that anyway.
That's usually most as hard as doing the invention. So to say, I should say, it's to get it out to the market somehow, some kind of market or whatever, a business model or whatever. So
I mean, sometimes we even, we never say that they should or they shouldn't, but sometimes we can give them the advice that, maybe the patent isn't the only way of actually protecting something. No. Because it takes time and it can be expensive, and you also, when you patent something, you actually have to write down exactly how it works. So you actually tell everybody how it works.
Yeah, and it will become public, the application.
Yeah.
Even if it's not on the patent, the application will become public. So you show everybody what you're doing, how you're doing it.
Yeah.
So it's kind of give back to society. You get the exclusive right. The society gets the solution in public.
So that's the trade-off. You get the exclusive right, but then you also tell everybody how it works.
Yeah.
So that's something. So we have that's the patent part. What else? What other kinds of obvious protection do we have?
Software is copyright protected, like a book. Or like an art.
So software is we were talking about code before, but software is copyright protected because
it's text.
Yeah.
And it's copyright. Just like that. Not the idea behind the software. It's how you express the idea.
So the actual written code is copyrighted.
Yes.
And copyright isn't something you don't need to apply for copyright.
No. It's just automatically when you're writing your code or you're writing your book, it's copyright.
Yeah. So as you
if it's kind of not you can't copy somebody else's.
No. But again, it has to be something novel that you.
Yes.
So you write your own text, either a book or a code or whatever it could be, and when you publish that, the copyright
arises. Oh, it arises when you are writing it, so to say.
Yeah.
At that moment.
The act of writing it creates copyright. That's okay. Well, that's
so it's fast. It's quick. A patent application takes time.
Yeah.
But a copyright is there.
And how strong a protection is that? I mean, what's your experience? You have an experience from like when copyright has actually helped a creator is it how?
Because it's copyright because you have done so much work on it.
Yeah.
Then you can sell it, package it like a software product, maybe.
Yeah, I know that in the music industry, the whole copyright thing has been a big thing. Because when you actually write a song or create lyrics or something, then you get the copyright to that.
Yeah.
And I know that you always read about people that are suing each other because they use, oh, I wrote that song and you played the same, and they're always trying to determine how many seconds of a song you've actually used to
infringe the copyright.
Indeed.
Yes. Yeah, it's a judgment. So
okay, so
it's not that strong as a patent, I should say, but it's still strong for some kinds of products and some kinds of and the only one you can use for software.
But let's do it also. Let's on the other side. One thing that we see happening, and that we want to deter people from doing is just like when you go to a website, you have terms of service and you have all of the legal text. There seems to be this idea that you could just go somewhere and they can take somebody else's terms of service and legal texts and everything like that, and then use it for your own website.
Yes,
but you can't. Not really, because that's actually copyrighted.
That's copyrighted as well, because it's written down.
Yes.
As somebody has created that one, the text.
Indeed. So you just can't take somebody else's terms of service and legal text on their websites and use it for your own, because that is actually an infringement of copyright.
Yeah, you shouldn't do it with a book.
No.
But it's so easy when you have it on the computer.
Exactly.
So,
it's indeed. So we have
and you hear music on the computer, and it's so easy. It's so easy. It's hard to write the book.
Yeah, but it was like when we had in the beginning of digital music, when there were MP3s and people were like ripping CDs, and there were like MP3 files all over the place, and then it was like, well, it's free music, isn't it? And it wasn't.
No.
But
because you can do it, it's not free. I mean, if somebody else owns it, so to say.
Somebody has created it.
Yeah.
And I always say, when I've been running things where we've created games or books or whatever, and people have been saying, well, let's just we can just use this software. We'll use this software, or we'll do something like that. And I said, well, you can't create something you want to sell commercially on something that you've stolen yourself.
No. Exactly.
That's just being hypocritical. You have to have respect the
others.
Yes.
And you want others to respect your creative work.
Exactly. I mean, you're expecting them to. You're expected to charge money for what you're selling. You don't want people just to steal your stuff. So
don't steal
you need to respect others for that as well. So yes. So that's patents. You have copyrights. What else is that? A normal kind of thing that comes into play.
It could be trade secrets, I think.
Trade secrets. Yeah, that's an unusual one.
Yes,
I mean, that's maybe not the first one we get, but how does that work?
That you decide to keep things secret, and then you have to be secret about it, to keep it locked in somewhere or locked down or whatever. Just keep it secret, so nobody can use it or see it, and it's like a black box, I should say.
Yes.
You should have like a black algorithms are usually used in.
And that's usually called, that method is usually called black box as well.
Yes.
Sometimes.
Yes. Because it could be a way.
Yeah. And this is it. I mean, this is like, the Coca-Cola recipe or the Kentucky Fried Chicken recipe locked away in a safe.
Yeah.
Nobody knows the recipe for Kentucky. Yeah, whatever. So that's an example of one of those trade secret ways.
Google have trade secrets. Spotify, they have lawsuit now about trade secrets.
They do?
Yeah. They have been accused for stealing the trade secrets from a Canadian company.
I didn't know.
It's a big thing.
Okay, you see? Well,
they are stealing. They are stealing.
Yeah.
We don't know yet, but they're accused.
We don't, but that have been accused. Yeah, okay. So and that is actually, I'll say, not opposed to, but if you have patents on one side, and if you don't want to tell the world about how you do it, then the whole trade secret black box way is a kind of a usual way of simply not telling people how you do it.
Yes, exactly. And it's often you use both patent and trade secrets and copyright.
Yeah.
So,
and trademarks.
And trademarks.
We haven't come to that yet.
That's a fun. You like trademarks, don't you?
I know. I love trademarks. So what is a trademark?
That's something that distinguishes you from others. I should say. It could be a service or it could be a product.
And it can be both the actual name, as in the word, but it can also be like a logotype.
It could be a smell.
A smell.
Like can
you actually brand?
You can brand this with a smell. Yes.
Wow.
Or a song.
So then maybe I'm without me knowing.
Hemdas.
Sorry.
Hemdas.
Oh yeah, the
Yeah.
Swedish ice cream truck
Yeah.
song.
Yeah, he's protected. By
Oh, okay. I know. I've heard rumors that the Harley Davidson sound, the sound of the motorcycle, was the trademark as well.
Yes, I'm not sure about that.
Neither am I. Maybe it's just a myth.
Yeah, but I think they tried to. I
Yeah.
don't know if they, I mean, really
But
managed to get a trademark.
and this is something I have no idea about. But you're saying a smell. But I would think then, like, Chanel No. 5. Could they have a?
They're trying, but it's hard to be with smell.
Yeah.
And the only one I know is when you open your tennis balls, and it smells like you cut lawn and grass.
Is that?
Yeah.
I had no idea. That is the funniest thing ever.
And then you get a positive feeling when you open this kind of jar with kind of smells fresh. Tennis.
Wow.
Yes.
Okay, cool. Well, you can protect almost anything in different kinds of ways, right?
Yeah. And candy here in Sweden are very popular to protect with the trademark.
Yeah.
The skull with the licorice and raspberry.
Is that trademarked?
Yes, it's trademarked.
Oh, wow. Well, anything that is, How about but you can't trademark anything which is like a household known name. I mean,
it can't be description of what you're doing, so to say.
No, like a generic thing.
No, you can't say you're going to sell tables and then you shouldn't have. I mean, you can't have a trademark table for tables, so to say. No, because other one. I mean, you have to use it for tables, so to say. But you can have the trademark table for selling other things.
But I know that is one of the problems I know when people are starting companies and they trying to choose a company name. The trademark branding issue comes into play because then you have to pick a name that
it's not occupied on something.
Isn't done by anybody else, or it doesn't sound too similar to something else, or like you wouldn't have anything called Coca-Cola or whatever.
Or Fika.
Yeah, exactly.
Selling furniture.
Yeah, especially if you're doing the same thing as well.
You have to do the same thing, or it's because that's the way it works.
Yeah, but what if I call myself IKEA and I did something completely different?
I think that should be a problem as well because it's IKEA, because they have a very strong trademark. They have a very strong trademark. So, but if it's not that strong, not that obvious that you are thinking about IKEA.
But that's the thing with trademarks, is that there are a number of classes as well. I mean, what they call classes. You were saying, like, okay, well, if you sell furniture, you can trademark your name in selling furniture.
Yeah.
But then maybe somebody else could have the same name selling ice cream.
Exactly.
Could have. Yes.
Yes. Unless you have a very, very strong, like Coca-Cola, IKEA. And
but then usually they also usually have paid for. In all.
Countries in all classes and different classes as well, if they use the trademark in that class.
Yeah. It's fascinating stuff. I think it's super interesting. But and the thing is, another thing that we often get is when we talk about patents and hardware or research and the more what you think is patentable stuff.
Yes.
And then people come and say, we're doing a software thing, so we don't have anything to do with intellectual assets, and we don't have anything to do with intellectual property at all. But that's not true.
No, we meet them a lot here at the Innovation
Office.
And then it's a mess. Because the ownership belongs to the creator and who created what.
Yeah.
And it could be years ago. So it's pretty hard. Sometimes impossible to know if you are able to use the product at all, because somebody else can own it.
If you're working with developers, this is something that we've worked on together. If we're working with developers like offshore or in other countries, make sure that you know where the code is.
Exactly.
Make sure that the agreements you write with the developers state that you actually own right to the code.
Yeah. And if you're a team, decide.
Yes.
How are you going to do it with the ownership?
Yeah. And that's another thing that we also see is that the team starts and they start, accumulating assets. Like somebody registers a domain name, somebody takes a trademark, and somebody does something else. And then when they start a company, they forget to actually transfer the rights into the company, and they still own them personally. And then somebody leaves the company, and then 2 years later, somebody says, "Yeah, but who owns the domain name?" And oh, well, he quit 2 years ago, and then the domain name is, in somebody's personal account. So that's also something to look out for. To make sure that you aggregate all of your assets.
Yeah, and all of a sudden somebody disappeared because it was a cousin's girlfriend. They have to give it a code, and she all of a sudden just not there anymore. So,
well, I'm
4 years after,
I'm not going to say it happens all the time, but variations of this theme we see very often.
Yeah.
So make sure that it's not only about patentable inventions. Whatever you are doing, you will create and aggregate intellectual property.
Yeah, intangible assets.
Yes, intangible assets. So first of all, you need to just understand what are we doing, what kind of stuff will we be aggregating, and what of it is worth or should we protect?
Yeah, you have to prioritize. You can't protect everything.
No, but you have to, you have to prioritize and choose what you want to protect.
Yes.
Exactly.
Yeah.
And then to do it.
Can do it.
How much?
Sometimes it's good then when you have this is our prime asset. This is so important for us.
Yeah.
Then you maybe think about taking up. Is it patent maybe?
Yeah.
I should apply for, or is it just a trademark, or is it just keep it secret?
What does a patent cost?
It depends.
How long is the rope? how much does that fish weigh? No, but
if you apply for a patent in Sweden, just in Sweden, I think you should have about 100,000 Swedish kronor at least.
But
that's just for Sweden.
Yes, but is that for applying, and is it
It's for applying. The application usually costs about 50,000.
50, yeah.
Yeah, because you probably need some help to write the application.
Yeah.
It's wise to have help writing the application because it's kind of legal text. And then you get an answering you have to answer some questions from the patent office.
Mm.
And then you have to have the official fees at the end. So I think 100,000.
But it's two fees. First, there's an application process where you write the application. That will cost.
And usually you have to do some pre-work before you apply as well.
Yeah. The pre-work is
to see what prior art are in the field.
Yeah. And what does that mean?
You have to see what is it. Is this new?
Yeah. That's the first thing.
I mean, otherwise you just throw the money in.
So step one: speak to Thorunn and do the get help with the pre-work. Is understanding is it even any point in trying to do this and getting a patent? That's step one. Step two is writing the application.
Yes.
And that will probably cost you money because you need a professional expert to help you write the application. Patent attorney. That's step two. Step three is to apply for the patent.
Yes.
That will cost some money.
Yeah. Not that expensive though in Sweden, but
but that's not so expensive.
No,
but that's
still a fee.
It's still a fee, smaller fee there, and then you wait for the verdict, which can take like a year, or how long can it take?
Usually I should say 2 years.
2 years.
Yes.
So it takes 2 years, and then they say you can get a patent.
Exactly.
And then you have to pay the patent fee
again.
And then it starts. From there, it starts costing bigger.
Then it costs every year.
Every year.
Yes.
Okay. So it's not I pay one and I have like a 20-year thing.
No, so you have to pay every year.
How long is a patent?
20 years you can pay.
20 years.
From the filing day.
Okay, so the filing day and then 2 years, so it's 18 years of
ish. Yeah. You have to pay the annual fees.
Okay.
And it's usually, I think it's in Sweden, it starts with 300 and then it ends up with 3,000 if you 20 a year.
And
approximately.
But would you recommend to start in Sweden only, or do you recommend to do it wider, or how do?
We always recommend to start in Sweden.
Yeah.
And it's easier and it's not that expensive. And then in a year, you have to decide if you want to go in other countries.
Yeah. And then do you pick?
And then you hopefully have some investor or some more money.
Yes.
So you have to work. I mean, it's not just to leave an application. You have to work hard in 12 months to raise some money.
Yeah, well, that's what we said in the beginning. Just because you have a patent doesn't mean that you're going to make lots of money. It's like the other stuff that brings you the money. That's the important part. And look at the time. It's 5 to 3. I mean, we only have a half an hour coffee break here. We have so much more to cover and so many more things to ask. Just one more thing regarding patent. Is there a European patent? Is there a global patent? How does that work?
The European patent is coming. It's on the way, but I think it should take 5 or 6 years until it's finalized. But that's the only one. Then you have to have an application in each country.
In each country.
Yeah.
So in the end, you'll have to have it in each country you want to protect your rights. You have to have a patent application.
Yeah. There are some systems that
that sounds expensive on a global basis.
It is expensive.
Yeah.
So you have to be sure what you want to protect with the patent. And timing, I should say. Because if you're too early...
Of course. We're getting up to 3 o'clock. It's a half an hour coffee break. I know, I'm sorry for cutting this short here, but I don't want to leave without your top 3 tips of how to work with your intellectual property intangible assets. So Thorunn's top 3 tips, and we'll be commenting them along the way. Tip number 1 being manage intangible assets from the start. What does that mean?
Yes, we talked about copyright. I mean, it's instant protection by copyright by the author. And if it's hard to get back 4 or 5 years if you're not sure who owns the product or service. So start at day 1, I should say.
Yeah.
Taking notes, who owns what.
Yeah, who owns what, who created what, and start aggregating that list of assets as you build your company.
And if you get some external help, just take notes on it.
Yeah. If you're at KTH, you can always come to KTH Innovation and get free support and guidance in this. Don't forget that.
Yeah.
Thorunn and the rest of us is here to help you.
Maybe it's not that hard when you start, but if you have to go back 4 years, it's almost impossible.
Everything is harder when you have to go back 4 or 5 years and trying to figure out who did what, when, and who was what, and where did it go, and everything like that.
So please.
So please.
Save time.
Yeah, save our time as well. Tip number 2 from Thorunn is identify important activities.
Yeah, identify your primary intellectual assets. That's really important.
Yeah.
And focus on them, and that's gonna. I mean, it's kind of business model as well. If you focus on what is really important for you to achieve what you want in the end.
Yeah.
And then you save time as well.
Yeah,
I should say.
So figure out what you are aggregating, which are your prioritized assets, and focus on them and make sure that you have them listed and covered. And
and if you're a team, talk about them and decide what you're going to have them for.
Yeah. Tip number 3 from Thorunn is, sorry about that, take control.
Yeah, now it's patent maybe, or trademark. Maybe some special assets need some kind of special protection, I mean, like a patent or a trademark. Because it's easier to package and sell and censor asset if it's a patent trademark.
Yeah, but any kind of wrapping will make it easier for you to both sell and transfer and also state your case.
Yeah, and communicate with others what you do.
Indeed.
Yeah, what you have done.
And don't forget, you need to take control of your own assets and make sure that you protect them and own them. Otherwise, I'm not going to say otherwise somebody else will, but you have to look after your own thing. So as Thorunn said here, make sure to manage them from the start. Identify what you're aggregating, who has created what. Just make lists, write everything down, identify which ones are most important to protect and to work with. And then, just own it.
Yeah. You own your computer. You take care of your computer. Why shouldn't you take care of the other assets?
Exactly. With that, it is 14:59, and we'll be finishing here at 3 o'clock on the nose. Thorunn, thank you so much for coming by.
Thank you.
My weekly coffee break chat. Today in a different setting, as I said. You see here, we've set up the whole area here for Demo Day tomorrow here at KTH Innovation, Thursday, March 31st. But this has been the Wednesday coffee break. And with that, I will say thank you for this week. And next week, we'll be broadcasting again from here, live audience. It's going to be a big one next week with H&M Foundation.
Great.
It's going to be super cool. So make sure to join us next week and check us out. Check me out as well. All of the recordings on YouTube, all of the content on Medium. Thank you, Thorunn. And with that, I will say good afternoon.